This is the American Law Journal.
It sounds familiar. A product is released into the stream of commerce. The FDA receives complaints. There are injuries. Products are recalled. And now, here come the lawsuits. Good evening. I'm Christopher Naughton. Tonight, when medical devices fail, hip and knee replacements, breast and heart implants, and more. Four guests will join me in just a few moments. But first, the latest poster child in mass tort medical device litigation are hip replacements. And courts are doing a balancing act. Our producer, Valerie Jones, explains.
Late last year, word got out. DePuy Orthopedics, a division of Johnson & Johnson, pulled a popular hip replacement implant because people were getting hurt. Mobility issues, additional operations, and metal shavings in the blood causing fear of disease and dementia, making it ripe for a mass tort lawsuit.
Mass torts, because it affects different people in different ways, are different than class actions. The most important element of the mass tort situation is the differing degrees of harm sustained by the parties.
DePuy ASR metal-on-metal hip implants have been found to fail at a high rate, requiring patients to have the device removed and replaced in a hip revision surgery.
Are you a victim of the Johnson & Johnson DePuy Hip Implant recall? If the answer is yes, then you may be entitled to money damages.
As a drug and medical device lawyer, what I've noticed is that the internet has given plaintiffs' counsel access to clients that they would not have had access to 20 years ago. It's also given plaintiffs' counsel access to each other. 10 years ago, 15 years ago, the thought of plaintiff counsel around the country coming together and working as a singular unit on a mass tort litigation was really not heard of.
That may make it easier for people who think they have claims, but it does not guarantee them a settlement, and it requires something else.
The most important thing that consumers need to know about mass tort litigation is, number one, you are part of a larger group of people and that there is strength in numbers. Number two, you're in a case that is very complex, where oftentimes what we're facing from the consumer side is a case where profits were put over safety. In order to prove that for you, it's going to take extensive time, extensive research, and to be patient with us.
Ultimately, the burden falls on the court. In mass tort litigation, such as with hip implants, judges have to perform a balancing act.
The toughest issues for the judges are how to efficiently move the cases through the system and be fair to both the plaintiffs, the injured party, and also the defendant. And the judges have to fashion the litigation so that we reach a resolution, giving each plaintiff a fair shot and trying not to bankrupt a defendant.
For the American Law Journal, I'm Valerie Jones.
Balancing the interests between the plaintiff and the defendant. Maybe we'll get around to doing that on tonight's program. Four guests with me this evening, one joining us from Washington, D.C. Let's go ahead and meet them. Actually, he's come up from Washington, D.C. to be with us today. Raymond Milady from Blank Rome, from the Washington, D.C. office of Blank Rome, and he and the firm represent corporations in their counsel. He has been trying cases involving medical devices and pharmaceutical products now for over a quarter century. The Honorable Jack Piniella is with us tonight. And Jack, a former trial judge, and then after that stepped up to the appellate division, the appellate court in Pennsylvania. We call it the Superior Court in Pennsylvania. And a longtime practitioner and judge who's heard these kinds of cases in the past. Jamie Schiller's with us tonight from Schiller PC, with offices in New Jersey and Pennsylvania and elsewhere. And Jamie and her firm represent those who have been injured by dangerous drugs, dangerous medicines, dangerous products. The firm goes back, although Jamie certainly has been practicing since 1977, but the firm does have its roots in the 1970s and, in fact, has been involved in three of the largest Ketan whistleblower lawsuits in the nation over the last 15 months. And Diana Zuckerman is joining us by way of On the Line tonight. She is in Washington, D.C. tonight. She's the president of the National Research Center for Women and Families. And she, oddly enough, curiously enough, also has had a hip implant. And in fact, Diana, let me go to you first. I mean, here you are in some ways castigating, if you will, Johnson & Johnson and DePuy and the FDA for putting this product out on the market. And yet you have a DePuy implant and no problem so far.
for 6 months. Let me say that when I was trying to figure out what to do about my hip, and I am a relatively young woman, and certainly one that knew a lot more about medical devices than your typical patient. And I'm trained in epidemiology at Yale Medical School, so the first thing I did was look for any published research, any peer-reviewed research comparing different kinds of hip replacements to see which ones last longer and which ones seem better. And there's practically no information at all. I mean, even whether you're a patient, a typical patient, or a physician, there's virtually no useful information out there comparing different hip devices. Essentially,
there is more than one hip replacement device that is being litigated right now. I believe that there are several. And over 100,000 sold around the world. There are claims, of course, of design defect. I've seen that in some of the complaints. Allegations of metal rubbing against metal, repeat operations for a lot of these people. There's a fear of heart failure, a fear of dementia when the cobalt and chromium shavings get into someone's bloodstream. Many have said that the failure rate is 12 or more %. That's pretty shocking, but the question I have to ask you is if there are 30 or 40,000 people in the United States who have this implant right now, do all those people have a case? Can they all file suit, and should they all be filing
Well, the
suit?
company is instructing people that they must get the testing of their blood for the metals, the chromium and cobalt, every 3 months and repeat it if they have this defective product in their body. If they're symptomatic or those tests come back positive, they are instructed by the company's own recommendation that those hip implants must come out and be replaced. And these implants have only been in the United States since 2005. They're supposed to last 10 or 15 years. So they,
it's a relatively new science in some
correct.
ways.
So these things could go bad at any time in the next few years. So if you have it, yes, you must be carefully monitored. You should contact a lawyer. There's statute of limitations issues that the patient needs to be mindful of.
But you know what defense counsel and corporations are going to say, come on, Jamie, each and every one of these people are going to have this kind of a problem. Does everybody have a lawsuit? Is DePuy and Johnson & Johnson facing 40,000 cases? We heard Rosemary Pinto say in that feature package just a few moments ago, some people bring a claim, it's legitimate. Some people bring a claim, it's not legitimate. Look, so I'm asking the question before Ray Milady does.
Okay. Well, there's dozens and dozens and dozens of hip implants out on the market. And it's only a very limited amount of those total products out there that have a problem, that are in this case been recalled. Mm-hmm. The problem right now is that there's billions of dollars that were made off of the DePuy hip implant itself. It was fast-tracked through an expedited procedure with the FDA where there was no clinical testing. The company claimed it was substantially similar to prior products and therefore didn't need. It was basically grandfathered in. And in fact, it was much different than previous products, and now they're finding that it's failing. And the only reason they are finding that it's failing is not because of the reports in our country, because we don't have a mandatory complaint or failure reporting system. In England, in England and Wales, they have a joint and registry system where every hip is looked at, regardless of what company it is. So all the hips of all the companies, and there's dozens of them, are watched, and it's only the DePuy that's been failing at this enormously higher rate.
And that allows me to segue to actually pose a question to you, Ray, and that is, okay, not for lack of trying. Let's say for a moment there was no negligence here. I mean, there may have been a design defect, but regardless of that for a moment, if a company finds out that there's problems overseas with other folks, don't they have the affirmative duty to report that? There are reports that DePuy kind of hid some of these reports, tried to tamp down what was going on in Australia, keep things under wraps. Now, sooner or later, the truth is going to come out, but isn't that reprehensible? Doesn't the corporation owe us that much, even if they're putting a good product on the market?
Well, the companies, Chris, all know what their reporting obligations are, and I can't speak to the specific facts of the DePuy case. What I can tell you, make no mistake, these devices go through the highest level of scrutiny by the best scientists in the world who work for the government at FDA and understand all the medical literature. Look, there's a reason why the Supreme Court has held that there's a federal scheme that needs to be protected, and why some of these claims, these state tort law claims, are preempted, and that's a good law. And it's a good law because we know what would happen if the decision and if lay juries could dictate what's safe and effective
Chris,
and undermine the federal scheme. That just wouldn't work, Chris.
We'll get to you in just a minute, Diana and Judge, but we've got plaintiff and defense going at it here.
Supreme Court case was mindful of the fact that the FDA has absolutely no resources to test these devices or drugs themselves. They don't do. The public doesn't know that. The FDA does not take a device or a drug and test it. They don't have any labs. All they do is review the data that's produced to them by the companies. The companies can manipulate that data. The companies can hide data. And the FDA itself is a political animal.
But isn't
and
that
Wyeth versus Levin, which is the most recent Supreme Court case, says FDA approval is the floor. That's the minimum that the drug company has to do. If they find out or they've hidden or not brought forth the problems
not
for
for
drugs,
medical devices,
for the drugs, then they have to. The company is obligated to bring that forward because public safety.
You might have the moral high ground here, arguably. But the law seems to be stated pretty clearly that the Supreme Court has given protection that's different for a pharmaceutical drug versus a medical device like you're seeing on your screen right now.
4,000 devices a year are approved through the fast-track procedure of the FDA. 40 devices a year go through full clinical analysis by the FDA. 40,000, they get a free pass. 40 get the true review that my colleague here is discussing. That's the reality. And the FDA is a political animal. They are lobbied. The scientists, who are a lot of good people there who work hard, are often put down and have left the FDA, have made complaints public. You can read it in the New York Times. Anybody can Google it. Of scientists that had complaints, and the higher-ups pushed them down and didn't want to hear it and pushed the products through again and again.
So you're saying, well, and it may even be a political animal that goes to the Supreme Court, because I know plaintiffs' counsel are not very happy with the kinds of protections that manufacturers of medical devices enjoy. Judge, let me go to you for a minute, because I heard something really interesting in that feature report that we rolled in at the very top of the program. And one attorney, a plaintiff's attorney, said, you know, the court is juggling here. It's a balancing act. And they've got to make sure that plaintiffs have their day in court and that you don't bankrupt a corporation. Is that really what a trial judge should be thinking when he's hearing a case like that? Or is that just a pragmatic matter?
Well, first, let me say at the outset, Chris, boy, am I glad you put me in a separate room after hearing this discussion so far.
Oh, they'd leave you alone, Judge, you know that.
A problem that a lot of litigants face with thoughts that they're going to reach justice for maybe the reason that you just said. But they have a preconceived notion of what justice is. And when they get to court, Chris, and this is why I'm going to answer your question, the judge has to apply the law and only the law. So any theories behind what should be done, what's best for a certain industry, what's best for a certain plaintiff, whatever, none of that matters. The judge is there to apply the current law to the facts of the case that are before the judge.
In the ideal, Judge, but you know, when plaintiffs' counsel, even plaintiffs' counsel in that feature report said, you know, a judge is thinking maybe in the back of his mind, we don't want to bankrupt this company. Mm-hmm. I mean, I know you can't speak for other judges, but I mean, Ray, Jamie, do you think that that's sometimes, I mean, whether it's spoken or not, whether it's thought out loud and spoken out loud or not, is that really a consideration?
Chris, what I think the most important thing is for cases like this is that the judges apply the science. The science is critical in these cases. I couldn't help but notice on your graphics and opening up there was some speculation about whether the metal wear fragments that seem to be related to this implant might be causing systemic disease. My understanding is there is not a single peer-reviewed piece of medical literature that would connect the presence of these metals in the human body with some of the diseases that were so, shall I say, glibly put on the screen there. And your viewers are turning this program on and they're seeing that, oh my goodness, there's a connection between metal in this implant and neurological disorder. This is the problem when the science runs behind the litigation. And we saw that with breast implants.
Let me bring Diane Zuckerman in. Go ahead, Diana.
I'd love to get a word in here. It's very difficult. I'm sorry I'm not there in person. First of all, the protections for medical devices that the Supreme Court put in place do not apply in this case. They do not apply to the 510K process. And in Lohr versus Medtronic, the Supreme Court specifically agreed that the FDA 510K process cannot guarantee that a product is safe or effective, so it doesn't apply. It is absolutely a problem that there's a lack of research, whether it's research showing the kinds of neurological problems that were discussed or other problems. But the reason that that is a problem is because the FDA does not require clinical trials for these 510K, what they're called 510K devices, and it absolutely is a fast-track process. As Jamie said, it may not be a rubber stamp, but it absolutely is a fast-track process that is faster than the regular pre-market approval process, which is much more similar to the process for prescription drugs.
And I'll say what I said to Jamie. You might be right about that, Diana, but do you have the law on your side? And I guess this is maybe what this is going to come down to, what this mass tort litigation is going to come down to.
And there's absolutely studies going back many years of systemic problems with metallosis, when metal products and devices break down. There's a long body of literature and scientific methodology to back that up. And in fact, I personally have seen videos of my clients' explant surgeries of these recalled hips where you can see the metallosis reaction in their tissues. It's necrotic. There's brown and black fluid oozing out as soon as the doctor opens up their hip area to take out this failing device.
And I know none of us are docs here, and we often do have a doctor here on the panel when we're tackling a health-related issue. But these hip replacements that we're speaking about, those that are in play legally, isn't it because of a metal-on-metal device? In the past, I think most hip implants had metal and some plastic or some polyethylene around it.
There's also ceramic. In this particular
and these were designed for younger, more active people because they felt that the movement would be more fluid.
Correct. And
so
there's a couple reasons. It's metal on metal. There are other products, though, that are metal on metal on the market that don't cause the extreme reaction that the ASR does. It has to do with the metal on metal, but also the design of the cup and the weight bearing on it, because the cup is very small on a big ball, and it has a sharp edge on it, and the rubbing and the clearance between the ball and the cup and the way the product was designed is defective and causes a much more extensive amount of wearing and metal breakdown. And that's why this product should not have been approved through the 510K process, because it was not substantially similar to the other products on the market that did have pre-existing clinical studies. And the companies are so much in a rush to get the new and improved product out on the market so they can beat their competitors' market share. They're so worried about that they put any new and improved product. You're better off sticking with something that's on the market, whether it's a drug or device that's been on it for the long time. Anything new and improved is not tested, and it's, frankly, you have to be very careful.
And Diana, are you saying that then DePuy put this out on the market because it rode on the coattails of a substantially similar device and said, hey, under FDA laws,
FDA law, they're not even supposed to do an implanted medical device under a 510K process as substantially equivalent. Under the current law, it's a Class 3 device that should not have gone through a 510K, but the FDA in recent years has, as I think Jamie stated, almost all devices have been going through the 510K. And in fact, the General Accountability Office did a report showing that was against the law.
All right, and I just really want to, I think you folks have stated it here, but let's, again, for the lay people watching tonight, when you talk about a 5 or a 10K process, Raymond, again, what are we speaking about?
Well,
make it as succinct as possible.
The more elongated process is called pre-market approval, and that's where the manufacturer has to submit all of its own clinical data. But if there's a product out there that has PMA approval, then another product can come along and demonstrate through the 510K process that is substantially equivalent in design. And that way you don't require the manufacturer to repeat all those tests, because after all, there is a cost to the research and development that goes into these products. We want the consumer to get these products for the lowest possible cost. And this is why we have generic drugs, and this is why we have 510K medical devices.
So Diane, if there's a problem with this process, again, I call it the coattails, you folks call it the 510K process, to get it into the stream of commerce, why didn't the FDA say something, in 2003, 4, 5, I forget when these first hit the market, 5 or 6 years ago, why didn't they say, hey, whoa, you can't put that on the market, you can't slip this in on the coattails of something you think is substantially similar?
Right. Well, I think coattails is a great expression. It really describes it very well. But Also, you should just know that, for example, the person who was in charge of the Center for Devices at the FDA, after he was fired a year ago, went to work for device companies. So, you know, there's such a revolving door between the FDA and device companies that it's just not that surprising when people get rather cozy with particular companies and then leave the FDA and go to work for them. That is at least part of the reason why devices that, you know, it's okay to be substantially equivalent, similar, and on the coattails of another device, but by law, if a device is a high-risk device, which certainly a hip implant is because of the, you know, the severity of the surgery and the many terrible things that can happen if it goes wrong, by law, these devices are supposed to go through a more rigorous process that involves three things that are important. Number one, clinical trials. Number two, inspections of the manufacturing facility to make sure they're making it correctly. And number three, what's called post-market studies, where the FDA can tell the company that they have to keep studying the product even after it goes on the market, just to find out if bad things happen, such as what seems to be happening with these devices.
Okay, let's talk about the pragmatics now, because obviously there's a justiciable issue here. This is obviously going through our court systems here in the country. I'm going to go through each member of my panel, and I want a perspective from each of them. Jamie, people who have hip implants right now, how are they preparing? What should they be doing right now in light of the fact that this news has hit the papers and the media in general?
Well, I think they need to go to their doctor, find out if they have the recalled hip implant. And if they do, they need to get their chromium and cobalt tested. I think that they should immediately contact a lawyer. Their statute of limitations arguably starts to run from this August when the product was recalled, August of 2010. And, you know, they need to preserve their rights because there's a very good chance that if the device hasn't failed, it will. And a lot of patients, and I've talked to hundreds and hundreds and hundreds with the recalled hip implant, they had gone to their doctor back before the recall, complained of pain and different problems, and the doctor felt like, you know, well, it just takes some time, you're not quite being tough enough. And we have a voluntary adverse event reporting requirement here in the United States. We don't have an automatic registry of everybody's complaints, and it's a big problem. And the patient's complaints never really got recorded because the doctor just, you know, maybe didn't take them seriously or, you know, felt that it was exaggerated. And so I think now that it is being looked at with an open mind, that a lot of these complaints are really going to be tracked down the way they should have in the first place and reported to the FDA, and we'll get a real sense of the true scope and problem with this product.
Ray Mulady, again, you're not involved directly with hip replacement litigation, but you've tried dozens of trials, pharmaceutical and medical device litigation. You can't prophesy as to what they're doing right now, but what do you think defense counsel is doing right now, realizing they're facing an onslaught of mass tort litigation, realizing that some of the PR and the press has not been very good, and that there seem to be some injuries? What do you think is going on in the war room there on defense?
Well, first of all, from everything I've seen, the company is acting completely responsibly in this process. They seem to be listening. They seem to be reaching out to the patients that have these devices, and as my colleague pointed out, eliciting medical laboratory results and referring them for follow-up care. But in terms of the defense of these cases, I think one of the real challenges is to push back against the rush to judgment. We're having a program right now where all sorts of assumptions are being made, scientifically and otherwise, culpability, scientific causation. All of this needs to be worked out through the court system, and it's unfortunate, again, that sometimes the talk shows and the plaintiff's blog kind of gets out a little bit ahead of the science. But let's assume there is a problem and that the company is addressing it. These cases have been filed individually in different courts around the country, but they've been consolidated now, as I understand it, in the Northern District of Ohio before a very capable judge in what we call an MDL proceeding. And everyone will get together and there will be shared information through the discovery process. And then the experts will get involved and we'll really begin to understand whether there's a scientific basis to cast all of these devices as defective.
Judge, when we get plaintiff lawyers and defense lawyers sitting down with the courts, and I know in Philadelphia, very well known for its mass tort litigation work. Apparently this is going to be amassed in northern Ohio. When it gets to that point, isn't that really tipping our hand that settlement is probably already in the discussions, or am I overreaching?
Settlement discussions would be much further down the road right now.
All right.
Katz
can I rephrase that, Your Honor?
Mm-hmm.
All right. That they're in preliminary discussions as to what might be just compensation for prospective injured parties. Have I stated it properly there, Judge?
Well, you've asked the question properly, but I don't think the court is anywhere near reaching that level of involvement.
All right.
Judge Katz has just recently set up some cases as his steering cases. In other words, he'll use them as examples to set up discovery deadlines and other deadlines to help move these cases along. By the way, the federal courts have also just recently decided, although there is federal preemption because of the pre-market approval regarding the hip replacement cases, New Jersey and California state courts are going to be permitted to process some of these cases through their state court systems.
I understand. Diana, what should people be aware of right now at this juncture of litigation, specifically dealing with hip replacements? What should the consumer know?
Well, but the problem is what we really need is long-term research. You know, what a patient really wants to know going into this, because let me tell you, this surgery is awful. I mean, it's painful. You can barely do anything for a month. You're not even allowed to drive a car. It's very debilitating. So patients deserve to know, how can they avoid having to have this surgery more than once every 15 years? You don't want to have it a year later because of a recall, and you don't even want to have it 10 years later because your implant has worn out.
Folks, if you need more information, though, go to our website, lawjournaltv.com. Again, every program that we produce here later goes up to the website as a broadcast. You can certainly call us or write to us if you have questions in almost 24 different areas of the law. If you need to find a name of an attorney on plaintiff or defense side of a matter, call us toll-free, 888-78-LAW-TV, or you may write to us at info@lawjournaltv.com. Go to our Facebook page, The American Law Journal. Just type it into the bar and check us out now on iTunes, where you can watch every program that we have produced in the last year. I want to thank my guest tonight, Raymond Mulady, who made the trip up from Washington, D.C. Thanks, Ray. Appreciate having you here.
Pleasure
from Blank Rome, the Honorable Jack Piniella joining us tonight for the first time, and certainly not the last. Jamie Scheller from the plaintiff's law firm of Scheller PC in Pennsylvania and other states as well. And Diana Zuckerman with the Center for Research. And we do have Diane's email address, or I should say website address, right there on the screen next to her picture, centerforresearch.org. Diana, thanks for joining us. And again, hopefully we'll have you here in the studios sometime in the future. So for all of us here at the American Law Journal, until next Monday night, case closed.
Tonight's American Law Journal has been made possible in part by Scheller PC, winning large verdicts for people injured by dangerous medicine, including antidepressants and antipsychotics, as well as medical malpractice and products liability claims. Pennsylvania, New Jersey, and Florida. Scheller, preserving the rights of the injured for over 30 years. Blank Rome, a national multi-practice firm for over 60 years, with more than 400 attorneys in 6 states and the District of Columbia. Blank Rome's highly regarded employment law practice provides representation and strategic advice for critical issues facing employers in today's workplace. And the Legal Intelligencer, the oldest law journal in the United States.